Bryan Kohberger returns to court, hoping to get the evidence the state has collected against him thrown out as his lawyers reveal new details about the night of the murders.
This witness has claimed that she's not sure what she heard or saw was real or whether it was a dream.
We know it wasn't a dream because they found the evidence discovered the next morning.
So Ann Taylor is saying the surviving roommate claimed to have memory problems and that she didn't know whether what she recalled was a dream or not. Taylor is questioning the surviving roommate's credibility.
There are 2 references to not remembering. A couple of days later, there's a 3rd interview, and there's references to not remembering, being drunk, a statement, "I don't know any of it." At page 406, "I don't know if this was real or in my mind was just like playing with me." These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation.
But the prosecution defended the surviving roommate's statements to the judge, saying her description of the man she saw in the house wearing all black never changed.
And the person was taller than she was, around 5'8". That's what's important. It was that general description. And that general description did not change.
It's also important to establish the timeline.
It is. It's important to establish the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 11:22 and then leaves, as well as text communications of her relaying what she's observing during the same time period.
There, Assistant Prosecutor Ashley Jennings said one of the surviving roommates was texting what she was seeing. That is really interesting and had been rumored on social media.
Because when an eyewitness states she's not sure anything she saw was real, well, the simple answer is investigators knew what she saw was real because they found the evidence discovered the next morning.
They're acting like information that this roommate said was left out of the affidavit and that would have maybe not added up to probable cause.
Well, first of all, the statements in the affidavit to qualify for traversing the warrant have to be knowingly false and they have to be material. There's always going to be I don't want to call them lies or falsities, but maybe some misrepresentations, some inaccuracies in affidavits. The question is, if you sever those inaccuracies from the affidavit, is there still sufficient facts to find probable cause? And I believe that was the prosecution's argument. Let's just give them that. But there was nothing flagrant, nothing knowingly misleading about what the roommate may have remembered or saw, because at the end of the day, all that really matters, they have 4 dead people in that house. I mean, seriously, there is enough right there to suggest that a crime has been committed and that by going in, you might be able to solve it, get some leads, find something to lead to the identity of the perpetrator. So I think in the end, the court's not going to traverse the warrant, but instead might say, look, I might sever some of this, but I'm going to find nonetheless that there's still sufficient probable cause to allow this warrant to survive.
And the judge basically said, isn't his DNA on the knife sheath probable cause every day and twice on Sunday? And then Ann Taylor responds and says, not in this context because of the investigative genealogy work.
We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. What they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide at a crime scene.
What he left out in that statement he made there is inside a bedroom, people were brutally murdered by a knife. A brutal crime scene. The weapon, as we know, was never recovered. So this is the knife inside this knife sheath. But it's right here. This is a metal button. And that's where the DNA was recovered from there.
That's the DNA that was recovered from there. They swabbed it and got the DNA from
IgG was used in this case. And yes, it did point to the defendant. But the fact that that happened doesn't mean that there was a violation of the Fourth Amendment.
The FBI, in fact, violated the Fourth Amendment rights of Mr. Kohberger. You would agree the state burdened by that?
That's a great way of putting it, Your Honor. Yes, the state would be burdened by that. Yes.
Let's just pretend that what the police did was illegal and they came up with this whole family tree. The question then is the discovery of the family tree so far attenuated from the illegality that you can deny suppression? And I think it's very possible that if the court finds that Bryan does have standing, that the discovery of the genealogy type genetic data is so far attenuated from the illegality that exclusion is not the remedy. And you have to understand there's always going to be some type of remote discovery of things flowing from an illegality. That's the whole point. It would be different if they found his DNA directly in the database. Then the question becomes, did they need a warrant? But the fact that they found somebody else's DNA that had some matching genetic components to him, I think the court's going to find that not enough to say that suppression is the remedy. And frankly, I'm going to bet that this judge finds that he doesn't even have standing. And the reason why is that the right to suppress has to be personal to him, and that the thing that he is seeking to suppress has to be personal to him. The courts have held since Rakes versus Illinois that if the item that's being searched or seized is not yours, you don't have standing. You cannot assert the rights of third parties who may have had a privacy violation unless those people are being prosecuted and unless those people seek to enforce their rights. Some unrelated defendant has no remedy.
How in God's name did Bryan Kohberger in 9 minutes go into 1122 King Road and murder 4 students viciously by knife and only leave that? This is what's got everybody going, Ed. Leave that one little bit of DNA on that night sheath and nowhere else. No spit, no dripping sweat, no hairs, no fibers. Ed, please explain that to us.
He's wearing new clothes, black clothes for this attack. He's got a hoodie. He's got a mask. Okay, he's got gloves.
He PPE'd up like you would do when you were doing the pressure washing of the roof and using Clorox and bleach or whatever you used.
Well, not Tyvek, but you can go out and get clean, fresh clothes that don't really have your DNA on the outside of it, and then you wear some rubber gloves and you put the mask on, and then you put the clothing on, and you keep all the hair inside and so forth.
But I mean, Ed, this is why people are not sure about this, because that's a sticking point.
No, we don't know that there was nothing, but let me just say this. Absence of evidence is not evidence of absence. There could be DNA there. There could be DNA there and other forms of evidence. It's just that the crime scene investigators didn't find it and didn't collect it. Okay. But they got we know the murder weapon was a K-bar knife, right? We know that the sheath for the K-bar knife was found under one of the dead victims on the bed, and his DNA was on that snap.
Yeah.
Okay. We got the cell phone. We got the cars. We got the video of the cars driving around. He came back the next morning to the house to drive around the house.
Runner, there was no warrant for several phases of the search.
When there's a DNA match between the DNA and the sheath and Mr. Kohberger, isn't that probable cause every day and twice on Sunday?
That was another. I got to put you on, Ed, because you put your head down and you actually were like, "What in the actual F?"
If there was like a bobblehead of the defense attorney on the judge's bench, you know what he's doing? He's just smacking the head right now, watching it go.
And he's just like this, he's leaning to his right, and he is just like, what in the F am I hearing here? I got to say, the difference between Judge from, and no disrespect to Judge over in Latah County, the difference between Judge and Judge Hippler is night and day. This guy is no nonsense. He knows his stuff. And he basically is not lollygagging anything. There is no lollygag to this guy's game.
I prepared for the show watching a lot of the videos that were out there on this. And, you had a lot of of her peers, defense attorneys, come on and talk about it. They're shaking their heads, and they don't know what's going on, and they're defense attorneys. And it's, I mean, is she not picking up the vibes from the judge? Is she not reading the room? These arguments aren't selling.
Yeah.
Okay. And they're ridiculous. First of all, they're just totally asinine.